under protest. 152.1. Where a bill has been protested for non payment, any person may intervene and pay it under protest for the honor of any party liable thereon, or for the honor of the person for whose account the bill is drawn. If more than one offer, two. Where two or more persons offer to pay a bill for the honor of different parties, the person whose payment will discharge most parties to the bill has the preference. Refuse to receive payment. 3. Where the holder of a bill refuses to receive payment under protest, he loses his right of recourse against any party who would have been discharged by that payment. Meaning, if you choose to use another negotiable instrument to pay the debt and they refuse it, an offering of tendering of payment made and refused liberates the debtor. Entitled to bill. 4. The payer for honor, on paying to the holder the amount of the bill and the notarial expenses incidental to its dishonor, it is entitled to receive both the bill itself and the protest. Liability for refusing. 5. Where the holder does not, on demand in a case described in Section 4, deliver up the bill and protest, he is liable to the payer for honor in damages. Attestation of payment for honor. 153.1. Payment for honor under protest in order to operate as such and not as a mere voluntary payment must be attested by a notarial act of honor, which may be appended to the protest of or form an extension of it. Declaration. 2. The notarial act of honor must be founded on a declaration made by the payer for honor or his agent in that behalf, declaring his intentions to pay the bill for honor and for whose honor he pays. Discharge and subrogation. Where a bill has been paid for honor, all parties subsequent to the party for whose honor it is paid are discharged, but the payer for honor is subrogated for and succeeds to both the rights and duties of the holder with respect to the party for whose honor he pays, and all parties liable to that party. Lost instrument. Holder to have duplicate of lost bill. 155.1. Where a bill has been lost before it is overdue, the person who was the holder of it may apply to the drawer to give him another bill of the same tenor, giving security to the drawer, if required, to indemnify him against all persons whatever, in case the bill alleged to have been lost is found again. Refusal. 2. Where the drawer, on request, refuses to give a duplicate bill, he may be compelled to do so. Actions on lost bills. Action on lost bill. 156. In any action or proceeding on a bill, the court or a judge may order that the loss of the instrument shall not be set up if an indemnity is given to the satisfaction of the court or judge against the claims of any other person on the instrument in question. Bill in set. 157.1. Where a bill is drawn in a set, each part of the set being numbered and containing a reference to the other part, the whole of the parts constitute one bill. Acceptance. 2. The acceptance may be written on any part, but it must be written on one part only. Endorsing more than one part. 158.1. Where the holder of a set endorses two or more parts to different persons, he is liable on each such part, and every endorser subsequent to him is liable on the part he has himself endorsed as if the parts were separate bills. Negotiation to different holders. Where two or more parts of a set are negotiated to different holders in due course, the holder whose title first occurs is, as between such holders, deemed the true owner of the bill, but nothing in this subsection affects the rights of a person who in due course accepts or pays the part first presented to him, accepting more than one part. 3. Where the drawee accepts more than one part and such accepted parts get into the hands of different holders in due course, he is liable on every such part as if it were a separate bill. Payments without delivery. 4. When the acceptor of a bill drawn in a set pays it without requiring the part bearing his acceptance to be delivered up to him, and that part at maturity is outstanding in the hands of a holder in due course, he is liable to the holder thereof. Discharge. 5. Subject to this section, where any one part of a bill drawn in a set is discharged by payment or otherwise, the whole bill is discharged. Conflicts of laws. Requisites of form. 159. 1. Subject to subsection 2 and 3, where a bill drawn in one country is negotiated, accepted, or payable in another, the validity of the bill with respect to requisites in form is determined by the law of the place of issue, and the validity with respect to requisites in form of these supervening contracts, such as endorsements, acceptance, or acceptance under protest, is determined by the law of the place where the contract was made. Unstamped bills. 2. Where a bill is issued outside Canada, it is not invalid by reason only that it is not stamped in accordance with the law of the place of issue, conforming to the law of Canada. Where a bill issued outside of Canada conforms with respect to the requisites and form to the law of Canada, it may for the purpose of enforcing payment thereof be treated as valid as between all persons who negotiate, hold, or become parties to it in Canada. Law applicable. Subject to this act, the interpretation of the drawing, endorsement, acceptance, or acceptance under protest of a bill drawn in one country and negotiated, accepted, or payable in another is determined by the law of the place where the contract is made. But where an inland bill is endorsed in a foreign country, the endorsement shall, with respect to the payer, be interpreted according to the law of Canada. Law as to duties of the holder. 161. The duties of the holder with respect to presentment of a bill for acceptance or payment, and the necessity for the or sufficiency of a protest or notice of dishonor are determined by the law of the place where the act is done or the bill is dishonored. Currency. Where a bill is drawn out of but payable in Canada, and the sum payable is not expressed in the currency of Canada, the amount shall, in the absence of an express stipulation, be calculated according to the rate of exchange for sight drafts at the place of payment on the day the bill is payable. Due date. 163. Where a bill is drawn in one country and is payable in another country, the due date thereof is determined according to the law of the place where it is payable. Official images and electronic presentment. Definitions. 163.1. The following definitions apply in this section and sections 163.2 to 163.6. Bank has the same meaning as in section 164. Eligible bill. Eligible bill means a bill that is of a class specified by a bylaw, a rule, or a standard made under Canadian Payments Act. Official image, in respect of an eligible bill, means an image of that eligible bill created by or on behalf of a bank in accordance with bylaws, rules, or standards made under the Canadian Payments Act, together with any data in relation to the eligible bill prepared in accordance with those bylaws, rules, and standards, and includes a display, a printout, a copy, or any other output of that image and that data created by or on behalf of a bank in accordance with those bylaws, rules, and standards. Status of official image. 163.2. An official image of an eligible bill may be dealt with and used for all purposes as though it were the eligible bill. Electronic presentment. 163.3. 1. Despite anything in this act, a bank may present for payment an official image of an eligible bill electronically in accordance with the bylaws, rules, or standards made under the Canadian Payments Act, and if it does so, the requirements of this act respecting the presentment for payment of the eligible bill are deemed to have been complied with. Discharged by payment. 2. The eligible bill and its official image are discharged if payment in due course is made by or on behalf of the drawee after the electronic presentment for payment of the official image of the eligible bill. Presumption. 163.4. In the absence of the evidence to the contrary, a document purporting to be an official image of an eligible bill is presumed to be an official image of the eligible bill. Admissibility. 2. An official image of an eligible bill is admissible in evidence for all purposes for which the eligible bill would be admitted as evidence without proof that the official image was created by or on behalf of a bank in accordance with the bylaws, rules, or standards made under the Canadian Payments Act. True copy of contents. In the absence of evidence to the contrary, an official image of an eligible bill is presumed to be a true and exact copy of the contents of the eligible bill. And this is why you always want to go when you're negotiating any instruments, when you're doing any exchanges with the banks, you always want to have your own certified copies, ladies and gentlemen, because I am telling you right now, they alter every fucking thing they get their greasy little mitts on. Okay. They're always converting things. They're always altering. They're always converting it to pay to or pay to the order of or pay to bearer. So you want to have a true and accurate, correct copy. Know this when you go into a dealership or into a bank and you're going to get financed for something, or you're doing a consumer credit transaction, whatever the case may be, get the paperwork and do yourself a fucking favor. Walk the fuck out. Take the paperwork with you. You got 72 fucking hours to seal the deal. Go find your own notary. Go through the paperwork. Make sure they sign it first. Make sure the employees at the bank that are your securities intermediaries sign the instruments all first. And then go ahead and find your notary. Get everything signed. Take it all and alter it the way that you see fit. Remember, you're the one in charge of negotiating the best interest for yourself. Nobody else is going to do it for you. Take it up to the local courthouse, file it on public record, takes about a day, get all the copies back, or get all the originals back, and turn around and submit those back to the bank or the dealership or whoever you're doing business with. At that point, you have evidence on public record that they've accepted the contract. The only way that they can renege on the contract is if all parties involved in the contract decide to back out. If they're trying to back out, but you don't want to give way, guess what? They're still bound by that contract. All right. You must mutually decide that the contract isn't beneficial for all people involved, or all parties involved, dare I say, and back out together. So once they've signed these documents and you have your hands on them, you can alter them, you can change them any way you see fit, because after all, the one making the offer is the debtor, and they extended the application to you, and the one receiving the application and giving the consideration is in fact the creditor who gets to stipulate the terms and conditions. Never forget that, all right? Effective destruction. 163.5. If an eligible bill is destroyed in accordance with bylaws, rules, or standards made under the Canadian Payments Act, and there is an official image of the bill, A person's right and powers in relation to the eligible bill are not affected by reasons only that the person does not possess it. B, The destruction does not affect any person's rights, powers, duties, and eligibility or liabilities in relation to the eligible bill. And C, the eligible bill is not considered to be lost or to have been materially altered or intentionally canceled. Warranty 163.6. A bank that creates or purports to create an official image of an eligible bill, or on whose behalf an official image of an eligible bill is created or purported to be created, warrants that the official image or the purported official image, as the case may be, was created in accordance with bylaws, rules, or standards made under the Canadian Payments Act, and that is accurately represents the eligible bill. Damages. Any person who has suffered damages as a result of a breach of the warranty has cause of action for damages against the bank. Chapter 3. Checks on a bank. Definition of a bank. 164. In this part, bank includes every member of the Canadian Payments Association established under the Canadian Payments Act and every local cooperative credit society as defined in that act that is a member of a central as defined in the act that is a member of the Canadian Payments Association. Check 165. A check is a bill drawn on a bank payable on demand. Provisions as to bills apply. 2. Except as otherwise provided in this part, the provisions of this act applicable to a bill payable on demand apply to a check. Checks for deposit to account. Where a check is delivered to a bank for deposit to the credit of a person and the bank credits him with the amount of the check, the bank acquires all the rights and powers of a holder in due course of the check. Presentment for payment. 166.1. Subject to this act, A. Where a check is not presented for payment within a reasonable time of its issue, and the drawer or the person on whose account it is drawn had the right at the time of presentment, as between him and the bank, to have the check paid, and suffers actual damage through the delay, he is discharged to the extent of the damage. That is to say, to the extent to which the drawer or person is a creditor of the bank to a larger amount than he would have been had the check been paid. And B, the holder of the check with respect to which the drawer or person is discharged shall be a creditor in lieu of the drawer or person of the bank to the extent of the discharge, and entitled to recover the amount from it. Reasonable time. 2. In determining what is a reasonable time within this section, regard shall be had to the nature of the instrument, the usage of trade and of banks, and the facts of the particular case. Authority to pay. 167. The duty and authority of a bank to pay a check drawn on it by its customers are determined by A. Countermand of payment, or B. Notice of the customer's death. Crossed checks. Crossed generally. 168. Where a check bears across its face an addition of A. the word bank between two parallel transverse lines, either with or without the word not negotiable, or B, two parallel transverse lines simply, either with or without the words not negotiable, that addition constitutes a crossing, and the check is crossed generally. Crossed specially. Where a check bears across its face an addition of the name of a bank, either with or without the word not negotiable, that addition constitutes a crossing, and the check is crossed specially and to that bank.